Good afternoon, sir. A very good afternoon, sir.
Good afternoon. Good afternoon. Yes, tell me.
So, today is the episode of our anti-dumping webinar, which we have conducted. So, in the previous two webinars, we have explored the basics of anti-dumping as to imposed, how does customs, a basic custom differ from anti-dumping duty? What does product under consideration or PUC means? What is like article? How are the interested parties identified? So in this session, sir, I would like
Yes,
to focus on the legal and the litigation aspect of anti-dumping duties.
right.
My first question to you would be: so is there any landmark judgment as to what the Indian jurisprudence which has evolved on this subject? If I am a student of law who's interested in anti-dumping matters, what are the few cases which you will suggest that one must read?
Yes, thank you, Dev. So I think the most crucial judgment I would believe that which has been rendered in the context of anti-dumping. There are several judgments of the sestet also, because you see the appeal against the final finding lies with the Customs Excise and Service Tax Appellate Tribunal, sestet. So there are a number of sestet judgments, but one landmark judgment which comes to my mind and which I would like to discuss is the judgment of the Honorable Supreme Court in the case of Reliance Industries versus Designated Authority and others, which was reported in 2006, Volume 10, SCC, page 368. So this judgment, why it is crucial is that it lays down some of the essential principles, or what should I say, the why anti-dumping is necessary, entire historical background and everything. So in a nutshell, one can go through this judgment and read about the entire literature of the anti-dumping. So to start with, I mean, I will just refer to few observations of the Supreme Court in this particular judgment. And it talks about why, what is the necessity of anti-dumping duty? What is the genesis necessity of anti-dumping duty? It says that after India became independent in 1947, and I am referring to the judgment itself, a industrial policy resolution was adopted by the Indian government, which gave encouragement to the growth of the heavy industry and other industry, so that India become economically independent and a prosperous nation. Now, the result was that industrial base was created after India became independent, and there was some progress in that direction. And in this context, Honorable Supreme Court referred to the Section 9, capital A, which is the enabling section 9A of the Customs Tariff Act, which is the enabling provision for levy of the anti-dumping duty. And the Supreme Court says that the purpose of introduction of Section 9A was that our industries, which have been built after independence with great difficulties, must not to be allowed to be destroyed by unfair competition of some foreign companies. Dumping is a well-known method of unfair competition which is adopted by the foreign companies. This is done by selling goods at a very low price for some time so that domestic industries cannot compete and are thereby destroyed. And after such destruction is taken place, prices are again raised. So the purpose of anti-dumping law is to maintain a level playing field and prevent dumping while allowing for healthy competition. The purpose is not protectionism in the classical sense, but to prevent unfair trade practices. So the Supreme Court says, and it also refers that the 1995 introduction of 9A was made in pursuance of Article Roman 6 of the General Agreement on Tariff and Trade 1994, which is referred to as the GATT Agreement, GATT, which permitted anti-dumping measures such as an instrument of fair competition. So the concept of anti-dumping is founded on the basis that a foreign manufacturer sells below the normal value in order to destabilize domestic manufacturer. Dumping in short term may give some transitory benefits to the local customer on account of lower price good, but in the long run destroys the local industries and may have a drastic effect on the prices in the long term. So anti-dumping not only has a detrimental effect on the local industries, but certainly in the long run, it also affects the consumer. It may benefit the consumers in the short run as they are benefited by the lower prices, which is the dumped price in fact. But in the long run, the dumping causes injury not only to the domestic industry, but it also causes injury or the detrimental effect on the consumers. Now, another important aspect which was highlighted in the judgment is that injury determination is always for the domestic industry as a whole, and it cannot be and never be for individual companies. So while the anti-dumping authorities analyzes and tries to ascertain whether any dumping is taking place, it takes care of the interest of the entire domestic industry and not a particular company which may be dominant in the market. So it may be that what is being dumped benefits a few companies, as it may be a raw material for a few companies, but for the industry as a whole, it is a detrimental effect. So in that case, the larger interest of the industry and the consumers will be looked into. And it also talked about the process of the levy of the anti-dumping duty, and it said that the proceedings before the designated authority is quasi-judicial. Therefore, it must be in accordance with the principle of natural justice, and it must disclose the detailed reason for the levy of anti-dumping duty, so that anybody who is either for or against, they may challenge the decision if the judgment has complied with the natural justice and is detailed in has a detailed reason. And it also talks about the excesses when unwarranted claim of confidentiality, as the confidentiality clause which is there in rule 7. It said that excessive confidentiality affects the grounds, reasoning, and methodology by which the designated authority has arrived at its decision and made its recommendation, and the parties to the proceeding cannot effectively exercise their right to appeal either before the tribunal or before the court, and therefore excessive confidentiality without any reason is also not something very healthy. So I think it covered a lot of aspects relating to the rules, reason, and most of the aspects of the anti-dumping law. And this, according to me, is a must read for anybody who wants to learn about the anti-dumping law.
Thank you, sir. Sir, you were saying that if the notification, the final finding is out, say the investigation has happened, and then the
Yes,
anti-dumping authority, they take out a final finding. So there is a window of 3 months which is available before the notification is notified. A notification has to, as you have discussed earlier, sir, that a notification has to come within 3 months from the date of the publishing of final finding. Now, if a person is aggrieved by a final finding, say an
yes,
interested party is aggrieved by a final finding, so you had, sir,
yes,
pointed out that uh, one can approach the CESTAT against the final finding. So my question to
yes.
you is it the case always, or in few cases we can approach, say, invoke Article 226 and approach respective high courts as well against the final finding, sir?
You see, the primary challenge lies before the state under Section 9C of the Customs Tariff Act. That is the first point against the final finding. And there are two stages, as you have said, that one is the final finding by the designated authority, and secondly, the issuance of the notification by the government of India within 90 days. Either government might issue a notification, might not issue either. So there was an amendment in 2024 by virtue of which the interpretation with the prior to 2024, the law was that even the notification can be challenged before sestet. That was the view of the judiciary, because the Honorable Supreme Court also held that the notification issued by the government of India is a quasi-judicial exercise, and therefore it is amenable to challenge before the sestet. But now the amendment has taken place, and the government amendment to say that only the final finding by the anti-dumping authority can be challenged and not the notification. Now, after this issuance of the notification, the sestet, the anti-dumping bench, has not been taking up any matter. So now, since last 1.5 years or so, the only recourse which is available either against the final finding or after the issuance of the notification is the rate code. Now, here I must point out that in any case, even if suppose the tribunal is functional and we have a remedy before the sestet, still one can approach the writ court subject to there is a violation of the principle of natural justice. Either the interested party or the domestic industry has not been given a fair hearing, or the reason specified in the final finding is non-speaking. There are not enough reasons given in the order to enable either party, whether interested party or the consumer or the domestic industry, to appeal it before the sestet. Because you see, without a detailed reason, one cannot challenge, as to one does not know what was there in the mind of the authority to decide this way or that way. So if there is a violation of natural justice, or even suppose there is an excess of jurisdiction, there are certain parameters which the designated authority has to follow. There are certain boundaries within which they have to act. And if they goes beyond their jurisdiction and acts in excess of the jurisdiction, then one can always challenge it before the high courts under Article 226.
So I have a practical question, sir. So, say for example, there is a one particular company whose headquarters is situated in Bombay.
Yes,
He is importing his goods from a port in Tiruvananthapuram. Now, sir, the final finding has been issued by the Directorate General of Trade Remedies in Delhi. So now, if I am to challenge the final finding, sir, which writ court do I go? Do I challenge it in Delhi? Do I challenge it in Bombay because my corporate office is situated there, or do I challenge it before the Kerala High Court, since the goods which are coming to India are through a port in Tiruvananthapuram? in this case, sir, where would, like, which High Court will have the jurisdiction to entertain such a writ petition challenging the final finding if I am an interested party?
So, as an interested party, is it a raw material for you?
Yes, sir, it's a raw material for me.
So, where is your factory?
So my factory is situated in Kerala.
Kerala only. Okay. Now let us stretch the example a little more. You said you have a registered office in Bombay. You import it from the port of uh, which port you said?
Port in Kerala.
Port
The
in
port in,
Kerala, right? Now let us assume that the factory is in Tamil Nadu. And the final finding authority is in Delhi. Now, under Article 226, 2, wherever the part of cause of action is there, one can exercise the jurisdiction. In this particular case, since the final finding authority is based in Delhi, so definitely a cause of action has arose within the jurisdiction of the Delhi High Court. Secondly, the import is taking place from Kerala. So anti-dumping duty, the customs authority will levy it in the Kerala state. So the state of Kerala also has a jurisdiction. Now, thirdly, if suppose the factory is in Tamil Nadu, so ultimately the product is getting consumed in Tamil Nadu, and there is a consequential injury to the interested party in the state of Tamil Nadu because of the consumption of the raw material in the Tamil Nadu. So in all the states, wherever the part of cause of action is arising, one can always exercise the right to file an I mean
sir,
the writ petition.
I will
Now
have a follow-up
I will
question.
refer two of the judgments I think which are very relevant in this particular matter. One is about the jurisdiction part. So one is the JK Industries Limited versus Union of India, reported in 2005, volume 186, ELT, page 3, where it says, I'll just read out that the part of cause of action to be investigated arises at the place from where the export of India takes place from a foreign country or territory, at the place where import in Indian territory takes place, at a place where the injury to the domestic industry is caused, where the like article says that the investigation are manufactured in India, and or at a place where the article under investigation is put to industrial use. This is apart from the place where the investigation is initiated and proceeded with. So I think this answers your query. There is one more judgment on this aspect, which is a judgment, I guess, of the Guwahati High Court. I'll just tell you the citation. 1 second. No, this is a judgment of the Andhra Pradesh High Court. This is the citation is Wupala Mritha Magnetic Components Limited versus Union of India, reported in 2010, SCC Online AP 1107. Yes.
Sir, a follow-up question, sir. I would like to twist some facts there. So now the main company, the holding company is situated in Bombay. Now I have two subsidiaries, a subsidiary company. One where my factory is located in Tamil Nadu, and another subsidiary company is in Kerala, where my goods are, like, I'm importing the raw materials from a port in Kerala. Now, sir, if I am to file a writ petition, can I file the writ petition? Say if in Kerala I file it through a subsidiary company in Kerala High Court, And against the same final finding, I challenge the same final finding in the state of Tamil Nadu. Reason being, my factory is there, and I file another writ petition through a separate subsidiary company in Tamil Nadu. Can that be done, sir?
I think so. I mean, I don't find any difficulty. Whosoever is the affected party, they are affected by the action of the designated authority to levy anti-dumping duty. And if they satisfy the criteria of part of cause of action, as I've already discussed, then I think all entities, wherever they are situated, they can exercise their right to approach the Honorable High Court to file a writ petition.
Thank you, sir. So there's no other questions, sir. So we conclude this webinar, sir.
Okay.
Thank you so
So,
much, sir, for yeah, conducting such an insightful webinar on this topic. It's a very niche topic, sir, and it's indeed very interesting to know about this topic, sir.
yeah, thank you, Dev. And I think from next week, if possible, we'll try to discuss the new direct tax code, which has been, just announced, not yet become an act, but I think we can start learning, start discussing, and then probably it will help all of us.
Sure, sir.
Thank you.